So the buying process can be split into three parts, which is the pre-signing, the signing, and the post-signing. In the pre-signing phase, the buyer would familiarize himself with the property, collect documents and other information. He would then cater to the financing of the purchase price, and he would eventually negotiate and draft the purchase contract. In the signing, then, the latest draft of the purchase contract will be signed by the parties, thus creating legal obligations on the buyer and the seller. In the post-signing phase, then, the parties and the notary will implement the purchase contract, cater to the due conditions for the purchase price payment. They will cater to the handover and eventually cater to transfer of title to the buyer. Strictly speaking, it's not required to hire a lawyer to buy properties here. However, it's highly recommended because lawyers can be helpful in all of the three phases that I've just outlined. Yeah? So in the pre-signing, they can help the buyer in reviewing the documents, negotiating the purchase contract, and eventually also drafting the purchase contract. In the signing itself, the lawyers can represent the buyer at the notary's office in the signing process, and also help make necessary last-minute amendments if they should occur. And then in the post-signing phase, the lawyers would help in the implementation phase in monitoring what's going on in the land registry with banks and so forth, keep the client informed, and also help him through any troubles should they occur. So essentially, the lawyers would be both a defense for the client should anything happen, but also an insurance that he's doing the right thing at the right time. Well, the notary, whilst he is also a lawyer, he is not entitled to act on behalf of either party. He acts much more in a public capacity, where in the public interest he would record the purchase contract for the parties. He would help draft the purchase contract as well, but only the technical provisions and not the commercial provisions. The notary will then, in the signing, read out the whole purchase contract to the parties, i.e. recording their will to make legal obligations. And then he would enter into the implementation phase, the third part of the transaction, where this is the main job then of the notary to apply to the land registry for the necessary securities for the buyer, but also for the buyer's bank, talk to the seller's bank, get a release of securities there, and then inform the parties of the due date for the purchase price, and eventually register the transfer of title as well. That's a question we get asked a lot, especially by foreign investors. And I fully appreciate that it might seem long for this process to complete. Our best guess that it's going to be 3 to 9 months upon signing for a ready-made property. However, this can vary greatly according to the caseload in the land registry, who is actually registering the title for the buyer, but also on whether the purchase is an off-plan development or a ready-built property. The main reason for this being so long drawn out is that the transfer of title is the last step to be completed in the land registry, which is a public office where processes are highly technical, sometimes cumbersome, but at the same time, on the other hand, it's the flip side of having one of the securest real estate transfer systems in the world. So the keys, as well as the use of the property, will be handed over usually upon purchase price payment. So from the day following purchase price payment, the new buyer would be entitled to make use of the property, take any income from the property, but he would also be required to pay any expenses from the property. Therefore, commercially, the buyer will be treated as an owner from the date of this handover onwards. That's why we call the handover the change of commercial ownership as well.